All right, today's video is going to be about how the divorce process works its way through the courts. We're going to talk about the process you go through to get a divorce. Now, why are we doing this? Well, oftentimes people will ask us and they want us to give them a 25 words or less explanation. And we can do that, but they often find themselves knowing less than when they started or having more questions than when they began. So I'm Eric Johnson, the attorney here at Utah Family Law LLC, and I have my legal assistant, Brian. Now, Brian is not a lawyer, but he's done some work on this sort of thing, but I'm going to have him take the role of someone who might ask me questions that I didn't think to cover as I'm going through this, because that's the other problem we often have. Even if I do get plenty of time to tell people how divorce works, I often will overlook certain parts of it because I do it so often. You know how it is, as if you've been driving your whole life. Teaching someone to drive is a lot more difficult than you thought because you've already become so accustomed to things. Things are such habit that you don't remember to tell people to do a lot of things. And so you find out a lot of the steps you've missed along the way. That's what we're going to avoid here today. All right, so Brian, you come to me and you say that you want to file for divorce. Okay. All right, so I'm going to tell you the first thing you've got to do, and could you hold this board for me just to make sure it doesn't shake? The first thing I'm going to tell you have to do is to file a complaint. Every lawsuit, more or less, is started with a complaint, and a divorce is a lawsuit. It's no different. It gets filed with the court, and you file a complaint. Sometimes you may also see divorce actions entitled a petition for divorce. That's technically incorrect, but the court will still accept it. So you file this complaint or petition for divorce. All right. The next thing we do, once you have prepared the complaint I mentioned, you file that with the court. You file it with the court. You take it to the courthouse. You can mail it to the courthouse. If you have an attorney, that attorney must electronically file it with the court. The next thing you do, after you've prepared your complaint, is you have to serve it. It's known as service of process. We're just going to write it down as service. Okay? Now, before I get too far ahead of myself, our complaint is where we tell the court who I am, that I'm a citizen, that I'm married, and therefore qualified to get a divorce. I can't get a divorce if I'm not married. And then the reasons why I'm getting a divorce, and the things I want the court to order in the divorce. So if we have children, I say, I want to be awarded custody, or I want us both to be awarded joint custody. I ask for a divorce on the basis of irreconcilable differences. You may have heard of that. Or I might say, my spouse was unfaithful to me, or my spouse is a drunk, or my spouse is physically abusive. You give your reasons. Then the next thing you'll do is you'll say, well, I think I should have alimony, or I don't think I should pay alimony. Here's how I want our marital debts to be divided. Here's how I want child custody to be awarded. This is what I want to do with our pensions. This is what I want to do with the house. Do I keep the house? Do we sell the house? Those are the sorts of things you'll put in your complaint. After you've filed it with the court, then you serve it. Now, Brian, just real briefly, what is service?
So service is when you have a third party. It can't be somebody related to you, or your friend or your brother.
Well, what about you? Can you do it yourself?
No, and you can't be yourself.
And why is that? Why does somebody else have to give a copy of the complaint to you?
Because it would look suspicious. It would obviously not be as forthcoming as
Yeah.
just hand
I
paperwork.
mean, first of all, you could say that you handed it to your spouse and never did. So you tell the court, gee, I don't know why my spouse didn't respond. I gave it to him 20 days ago. So what happens with service is you usually give it to a constable. Sometimes it's a sheriff's deputy or a police officer. There are also people who will just professionally serve process. That's all they do. They're just private citizens who do that. So you can usually hand it to somebody like that. You have to. And then this person will serve it. You can also serve by certified mail. But once you have the service accomplished, you then have to give the court notice that there's been what's called a return of service. You have to file proof that the service was accomplished, and that's often called a return of service, or an affidavit of return of service. I'm just going to write down return here. All right, so you've filed your complaint, you've served it. How many days does that person have to respond? In fact, why should they respond? Well, first of all, I'm going to write out here on the side, they have 21 days if they are served in the state of Utah. 21 days from the day they are first served to respond to your complaint for divorce. If they're out of state, it's even a longer period of time. Okay, so that person serves you today, for example, and that person will then file a return of service with the court saying, on today's August 13th. On August 13th, 2014, I served a copy of the complaint on Joe Blow. He also has to say that with service comes what? You give someone a copy of the complaint and what else?
And the summons.
The summons. The summons gets served with the complaint, and it's just a simple document that says, hey, spouse, you are being sued by your other spouse, and you have 21 days to file your answer. If you don't, it's basically like forfeiting the game, and a default judgment could be given to your spouse because you never bothered to respond and tell the court what you wanted. Now, the answer is the next part that comes up, as I mentioned. This is the answer to the complaint or the petition for divorce. When you look at a petition or a complaint for divorce, it will have allegations, and each one is a numbered paragraph. So what you need to do is you look through that, and it'll say, we are citizens of the state of Utah. You'll say, I admit. And it'll say, we were married in December of 1996. And you say, that's true as well. We have 3 children. That's true. So you will write admit, paragraph 1, admit, paragraph 2, admit, paragraph 3. Well, let's assume you get to the part where it says, I deserve a divorce because my spouse was unfaithful and committed adultery. Well, you didn't commit adultery. You know that. You know that your spouse is crazy or vindictive, and so you would then say, I deny that. So you either admit or deny each allegation against you. Well, Brian, that's all well and good as far as telling the court and your spouse what you think of in response to each of the allegations. But what if you, too, say, well, I may or may not want a divorce, but I certainly don't want it on the terms that my spouse is asking for in the complaint. What can you do in addition to simply answering the complaint?
So you can file a counter petition.
It's a counter petition, yes. So you can do an answer, and you can also, and most people do, frankly, it's called a counter petition or a counter claim. Okay, we'll call that so a counter petition or counter claim. And really what that is that your counter petition, your counter claim is a complaint of your own for divorce, where you will say, not only have I answered your allegations in your complaint against me, but I'm going to file my own complaint, and I'm going to give my own grounds as to why I deserve a divorce, and I'm going to tell the court what I want to get. Okay, so you filed your complaint, it's been served, there has to be a return of service filed with the court to let the court know that the service was in fact accomplished and let the clock of 21 days start counting down. That person then has to file an answer and or counter petition within 21 days. Now I'm going to erase this board and then we're going to continue as to what happens next. We've now covered the point at which you have received the complaint. You filed your answer. You've more than likely filed a counter petition or a counter claim. So how much time does your spouse have to respond to your complaint for divorce, which is called a counter petition or counter claim? Well, we'll just call this a CC for counterclaim. Your spouse has, just like you did, 21 days to respond. 21 days to respond. If that person does not, if your spouse does not respond within the 21 days, just as that your spouse could have defaulted you for failing to respond, you can default your spouse. Now let me tell you a little bit about that. Don't get your hopes up if you file for divorce and your spouse files on the 23rd day a response. That the court will probably just say, well, a couple of days late doesn't make a big difference, and the court's going to say, I'd much rather decide this case on the merits of the arguments being made back and forth than just letting somebody win on a forfeit. Same kind of thing. You know, nobody likes to win a game because the other side didn't show up to play. You like to know that you earned it. The court feels the same way. All right. But I did want you to know that it's 21 days, just the same thing as if you had been served as well. Now it gets interesting. The court has rules as to what you have to do and what you and your spouse have to exchange. These things are known as initial disclosures, and as part of those initial disclosures, there is a financial declaration. All right. Now, Brian, you have some experience with financial declarations working in this office, don't you?
Yes.
How easy are financial declarations to prepare?
It depends on how good you are at keeping track of your books and your taxes.
What does a financial declaration include?
3 years of taxes, W-2s, pay stubs.
bills.
Titles to
Yeah,
cars.
it basically is
property.
showing everything that you have when it comes to your income, your expenses, your debts, and your assets. You have to prepare one of those, and you have to exchange one with your spouse. How many days from the time that you have now complained, answered, and counterclaimed, how many days after you filed your counterclaim is the financial declaration due? Well, this is weird. If you are the person who filed the complaint, if you're known as the petitioner, that's funny, you're called the petitioner, but you call your action a complaint instead of a petition. Go figure. If you're the petitioner, you have to file your financial declaration and your initial disclosures, and we'll talk about those in just a second. Initial disclosures, financial declaration. You have to do that in 14 days from the date the answer and counterpetition, if there was a counterpetition, was filed. If you are the respondent, or the defendant, the person that's responding to the complaint for divorce, you have to file yours within 28 days of the time that the answer was filed. Now, let's assume that somebody filed 23 days after service. That 14-day clock starts after the filing and the service of that. That 28-day clock is based upon when it's supposed to be, when it was filed. It's also, and remember, don't take everything I say here as gospel, but let's assume that you filed an answer. Your initial disclosures and your financial declaration need to be exchanged with the other side, but you're looking at a 14-day period if you're the petitioner, 28 days if you're the respondent. There are some exceptions, but we're not going to focus on those fine details today. If you do not serve a financial declaration and initial disclosures on your spouse, then you can suffer certain penalties. One of them is that the assets or the money and the income and things like that you do not state on your financial declaration, and of course you don't state it if you don't exchange it, can actually, one of the sanctions the court can impose is that can be awarded to your spouse. You didn't disclose it, you didn't explain what it was, you didn't do it timely, so the court can just say, I'm going to award these things to your spouse. You have to take this seriously. Initial disclosures are where you're going to tell each other in advance, without having to ask, the people that are witnesses or that have information helpful to your case. You have to identify them by name, address, telephone number, and a brief description of the subject matter of what they know or what they would testify to. You also have to provide any documents, and documents aren't just printed documents with words on them. They can include receipts, they can include photographs, they can include things that aren't even documents as we would define them. Things such as audio recordings or digital recordings and computer disks and things like that. You have to disclose these things. They're called initial disclosures because you're handing them over right now voluntarily without having to be asked. Okay? Once you have done that, what's the next thing you can do? After you've made your initial disclosures, what's open to be done?
Discovery.
Discovery. Now, that's a term that most people have never heard of and don't know what it means. So we'll explain. If you watch any TV or movies about that feature a trial, you'll see that lawyers going up and handing people documents or turning on video screens and showing them slides or watching films, and then they may hand them the murder weapon and things like that. Well, how did they get those things? How do they know where these documents came from? That's the discovery process. So when you're going through a divorce, after you've made your initial disclosures and your financial declaration's been exchanged, you can then start to narrow the issues down and ask each other questions. If I'm getting a divorce from Brian, and currently in the state of Utah that's impossible, but the way things are going that may not be for much longer. If I'm getting a divorce from Brian and I think Brian has an account that he hasn't disclosed, I can then tell him, it's like, hey, isn't it true that you have a Zion's bank account? And isn't it true that it's a checking account? Or if Brian isn't telling me that, I can go to Zion's bank and I can say, please disclose to me and identify every account under the name Brian Godfrey, and here's his social security number, and tell me, even though he may not, or even though he may not remember, Zion's bank, give me all the information about any account you have. I can also take your deposition, which is basically your testimony under oath, but it's not taken in court. It can be taken in my office. These are discovery techniques. There are things called interrogatories, and it comes from the root interrogate. That's when you're asking questions. I can send you a list of questions that say, identify all of your bank accounts. Identify how many vehicles you own. Identify how many retirement accounts that you have. I can ask questions. I can say, are you going to declare bankruptcy soon? I may ask a question about, have you ever been convicted of a violent crime? Interrogatories. That's part of discovery. The next thing I can do is what's called a request for production of documents. It means just what it sounds like. I can ask Brian to say, hey, I think you have documents. I want you to produce your journal where you have your suicidal thoughts. I may not tell him that in the request, but I might say, if you have a journal or diary, produce it. Now, people, you might think, hey, well, those are my private thoughts. That's private. That's confidential. I don't have to divulge that. Yeah, you do. Almost anything is fair game in discovery. But I can also ask for other kinds of documents. I can ask for Brian's tax returns for his business, if I don't already have them. I can ask for photographs. I can ask for recordings. I can ask for information off his computer, all that sort of thing. Request for production of documents. The other thing I can also do is what's called requests for admission. And this is kind of weird, but it too is just the way it sounds. I can say, admit, Brian, that 2 years ago you broke our son's arm in a fit of rage. Yeah, and then he can either say, yes, I admit that, or he can deny it. Now, if it's true, but he doesn't want anybody to know about it, he can still deny it, which would then mean that I would have the trouble of saying, well, I thought he might admit to that, but now I realize I'm going to have to prove that in court. But if you'd admitted it, I would have said, great, now we don't have to worry about that. That becomes an established fact, and the court can take notice of that without me having to prove it. I can say, admit that you got a $20,000 bonus last year and hid it from me, didn't tell me about it. And then if he says, I admit that, again, I can tell the court, look, he admits that I get some of that money, or he denies it. That doesn't mean that it's false. He may be denying it because he never got one. Maybe I was just thinking he got money. But those are the things that you can ask about. I can ask for admissions to. Help me to narrow down the issue so I don't have to go in and prove everything if you're going to agree to it anyway. You're going to just cop to it already. That's the discovery process. Brian, how long in a divorce case in Utah does discovery last? Do you remember?
I'm trying to think the exact days.
180 days. 6 months.
Right.
That's the default. Okay? You get, from the time that you have made your initial disclosures and financial declarations have been exchanged, you have 180 days in which to start and complete discovery. Now, you can take longer if you need it, and I'm not supposed to tell people this, but almost always discovery can last more than 180 days if their lawyers aren't doing their jobs or aren't being very careful, or if the parties want to drag their feet. There's a lot of reasons why that can happen. The court, I have yet to see a court punish anybody for it going beyond 180 days if they both wanted it that way, or if there was a good excuse. You can also go shorter than 180 days, shorter than 6 months, but that's almost impossible too, because oftentimes, if you're the one who's eager to go faster, the opposing side will simply resist for the sake of jerking you around, because anything you want must be bad, so they'll oppose that. But 180 days is the period that you're given under the rules of civil procedure to conduct discovery. Taking depositions, exchanging interrogatories, requests for production of documents, requests for admissions. There's other things you can do in discovery that I haven't touched on yet, and that would be if there's children involved, you can ask for a custody evaluation. And that is what it sounds like. You have a child psychologist or a social worker or somebody like that appointed by the court, and either you or your spouse share in the cost of paying for that. It's not free. And that person will then talk to your children, may talk to you and other people, neighbors, family members, conduct psychological testing of you and the family to determine what that person would recommend the child custody award be. Should it be an award of child custody to you or to me, shared equally? Do we split the kids between us? Like, do you get all the boys and I get all the girls? Or, do you get 2 of the kids, the 2 oldest, and I get the 2 youngest? That sort of thing is what's called a custody evaluation. They're supposed to take 4 months. And I have yet to see one actually be done in that short, if you can believe that, a period of time. There are other things you can do as well, but essentially those are the things you'll see most often. Once discovery is done, it is up to one or both of the parties to tell the court, discovery is done and we're ready for trial. But before you can go to trial, if you haven't done this already, what do you have to do?
You can do mediation.
Mediation. Now, my guess is most of you watching this who are contemplating a divorce or know someone that's been through a divorce have heard of mediation. Mediation is required in the state of Utah. It is not something where you must settle in mediation. Obviously, if you had to settle in mediation, there would be no need for judges. They make you go to mediation and try to settle your case before it goes to trial. Mediation is the subject of another video that we've made, so we won't go into tremendous detail other than to tell you that you have to go to mediation, sit down with a mediator, you have to pay for the mediator, it is not provided as a service by the court. You and your spouse and your lawyers, if you have them, sit down and try to negotiate with the help of a mediator to keep things on an even keel, to make sure people don't scream and yell at each other and stay focused, and try to settle. You cannot go to trial until you've gone to mediation.
So the mediator, like you were saying, is kind of a third party apart from my attorney and my spouse's attorney.
That's right. A neutral person who's there hoping to help the parties reach a settlement if they want to settle. The mediator can't be a witness to what's said. The mediator can't come into court and make any recommendations. The person's just there to try to help you settle. Must you go to mediation in all situations? Well, it is required unless the court excuses you. So if your spouse says, well, it doesn't matter what we do in mediation. If you don't agree to what I ask for in my complaint or my counterpetition, then we're not going to settle. Or if the person is somebody you simply don't trust, you can go to the court and say, I really don't see the point in mediation. My spouse has told me it's my way or the highway, or my spouse is so untrustworthy, I would never sit down and make an agreement with him or her. And the court may let you out of mediation. That's a long shot, by the way. Okay. We have now covered all of this. We've gone to mediation or we've gotten it waived. Discovery is now closed. What happens next? We do what's known as certify the matter for trial. Certify for trial, and that's just a fancy way of saying that you are ready to go to trial. There's nothing left to do or that could be done. Discovery is closed. 180 days have passed. Mediation, that box has been checked. There's nothing left to do since we didn't settle than to go to trial. Now, once again, we'll erase the board and tell you what happens next. So we've spoken about the fact that if you didn't settle in mediation, then the next thing to do after discovery has closed, after discovery has ended, is to certify the case for trial. Before we move on to trial preparations, let me just tell you, you and your spouse, if you settle things on your own, do not have to go to mediation as the only way to settle. If you both agree on the terms, if you sit down in a lawyer's office, or if you don't have lawyers and just sit down across the table one evening and figure everything out, that's fine. If you've settled, whether it's mediation or between yourselves, you then prepare an agreement or some notice with the court to tell the court, we have settled and these are the terms we've settled on, and the court will then issue your decree of divorce based upon your settlement. But unfortunately, in this example, we have not settled, and so now we're going to trial. Is that the end of the world? Are you a failure as a human being if you go to trial? Absolutely not. I don't want to editorialize too much, but there is pressure sometimes for people to think, I must settle. Even if the terms are terrible, I don't want to go to trial. They're afraid of trial. Even their attorneys will try to scare people into not going to trial. You know why? It's because the attorneys don't want to go to trial. It's not because they are trying to spare you anything. If they do tell you, look, I can't do any better than this in trial than what's being offered to you now, and you believe them, then that's a good thing. But oftentimes attorneys will put pressure on people to settle to avoid trial because they're afraid their client can't pay for a trial, or because the attorneys aren't very good at trial and they're afraid to go in front of the judge in trial or go up against opposing counsel. All right, I just wanted to point that out. Well, we have now certified the case for trial. So what happens next? The court will then schedule what's known as a pre-trial conference. A pre-trial conference, and that's where the court has the parties and their lawyers, if they have them, meet with the judge, or if you're in cities or counties that have bigger populations, you'll meet with the court commissioner, and you'll sit down to find out what are the issues that have not been resolved. Did you resolve some of them in mediation? Did you agree that, okay, we're going to sell the house, we both know that, but all the other issues we're going to contest. You can do that, and the court will ask you what's been resolved and what has to be tried. What are the issues that the judge is going to decide because you and your spouse cannot agree? So you'll meet together for maybe a half hour, as little as a half hour sometimes, or maybe even a couple of hours to hash things out. Oftentimes the judge or your commissioner will try to persuade you to settle, or ask you if there's just not some chance that you could, but you don't have to settle, and it's just to figure out what are the issues that are going to be held or going to be heard in trial and what the judge has to decide. After you've got a pretrial conference, you'll then be given a trial date. And if you're wondering, trial dates usually are handed out between 2 to 3 or even 4 months after your pretrial. So if you think, well, we'll go to our pretrial conference on Monday and then we'll go to trial on Tuesday, not even close. I mean, it's possible, but extraordinarily unlikely. After your pretrial conference, you'll probably get a trial date assigned to you 2 or 3 months away. Then, once you go to trial, you've, again, seen enough TV and you've watched enough movies to know what happens in trial. We're not going to go and thrash that out. But after the trial is over, the next thing that happens is the court may either, at the end of the arguments, make a decision from the bench, is what it's called. Meaning that while you're there in court, right after you've presented your arguments in trial, the court can say, here's what my decisions are and this is what I'm going to do. Or the court can do what's called take it under advisement and say, well, thank you, everybody. It's been a long day. We're both very tired. It's beyond 5 o'clock. The courts do close up at 5 o'clock. So I can't make any decisions today, or I'm not prepared. I've got to think things over. I'll take the matter under advisement. Once that has happened, then the court will issue its findings of fact and conclusions of law. Okay, now we're just going to abbreviate that with FFCL. But just know that stands for Findings of Fact and Conclusions of Law. And that's where the court will say, here are the facts that I have determined from trial. I have determined that, yes, adultery was committed. I have determined that, yes, this child was abused or not abused. I determined that the parties have these respective retirement benefits. I have determined the value of the house to be $349,000. Facts. Facts that will bear upon the decisions the court is going to make and what kind of orders it will make when it issues its decree of divorce. And the conclusions of law are simply to say, I have jurisdiction over the parties, and I can issue these findings, and I can issue a decree of divorce. So the court will then do that, and then the court may tell the winning party, or the substantially prevailing party, to prepare findings of fact and conclusions of law, him or herself. And then the court will look at them and go, okay, yes, I agree, you got this right, this right, this right. No, that's not exactly what I meant, you need to change this. The court will actually put the burden on you to prepare those findings of fact and conclusions of law for the court's approval. The same thing will happen with the decree of divorce, which we're just going to abbreviate as DOD. Okay, the decree of divorce. The court will say, you won, Brian, and so I'm going to have you or your attorney be the one to prepare a proposed decree of divorce, submit it to me, the judge, I will read through it, and as long as you got it right, I will sign it, and that will be the order of the court. And if you got it wrong, the court can do two things. What can the court do? It can either make changes or just kick it back to you and say, unacceptable. I'm not going to sign this. You got it wrong. Now make sure that you get it right in conformity with what I told you to do. So you've got your findings of fact and conclusions of law and your decree of divorce. At that point, the case is over unless you want to appeal. Rarely do people appeal. It does happen, but it's expensive and it's not, I'm not the most laudatory when it comes to the job that our courts do in trials. I'm disappointed. Even when I've won, there are often times when I think I should have won bigger. Or when I've lost, I can't believe the reason the court used to say that I've lost. And so you can appeal, and you have a certain period of time in which to do that, and that's typically 30 days after the court has entered its final order. That's divorce. That's the process from start to finish. And as you can see, this took a lot longer than just a few seconds or a few minutes. But we hope that by showing this to you and laying it out, that you have a better understanding of how the process works. A divorce case, if it's going to go all the way to trial, is almost always going to take at least 6 months and probably closer to a year's time. That's just the way it goes because of the way people work and the way the courts work. We hope you found this interesting. At the end of this video, we're also going to give you a link to a PDF where you can pull that up, and it's actually got a flow chart explaining this whole process. I do have to mention one other thing, that in this past legislative session, you have to go to a divorce orientation and education class. If you are a parent of minor children, getting a divorce. Okay? Divorce orientation and education is what it's called. Now, you're not going to believe this in the 21st century, but this is a class that you have to attend in person. You cannot just pay a 99-cent iTunes fee and watch it online or go to the court and watch it online. If you live outside the state of Utah, they will send you a DVD for you to watch. But if you live in Utah, except for a few counties that are very sparsely populated, you must go to a 3-hour course. You have to pay $55. That's what it currently costs right now. And you cannot get a divorce until you've attended that course or unless the court waives it.
Isn't it 6? I think it's
not 6 hours. It's 3 hours long and it's $55.
Okay.
Yeah, it's $55. It usually goes from, they'll have them on weekends sometimes in the mornings for 3 hours, and they'll also hold them in the afternoons after work from 5 or 6 o'clock, 5:30 or 6 o'clock until 8:30 or 9 o'clock. Divorce orientation and education class. Now, here's a new thing too. You cannot get any kind of temporary orders or go to court after you've filed for divorce until you have attended this course first. So keep that in mind as well. I'm Eric Johnson from Utah Family Law LC. We hope this has been helpful. Look for the URL link for the PDF of the flow chart. And if you have any questions, we'll have our contact information at the end to give us a call.